Welcome. I'm Janet Levitt, the Dean of the TU College of Law. I want to welcome everyone to our fourth of this academic year, our fourth Faculty and Alumni Showcase series, where we invite our students, our alumni, friends of TU Law to the law school to hear about some of the work that our faculty is engaged in, and we have expanded that this year to invite some of our alumni from out of town in particular to hear about the work that they're engaged in. Today I'm very honored to introduce one of my colleagues, Professor Tom Arnold. Professor Arnold is truly a master teacher, as you can see by a number of his students who are here. He has won the University Teaching Award. He won that rather early in his career. It's been repeated by several law school, College of Law awards that he has received. And I will say that I, in meeting with students, constantly receive accolades about Tom Arnold's classes, both his first year contracts class and his upper level contracts agency courses. It's my sense in knowing Professor Arnold that his interest in corporate structures, in corporate liability, and corporate accounting issues, and his teaching and his students really sparked an interest in corporate social responsibility. I hesitate using the word social responsibility, but I will, corporate human rights. And he has really taken this interest on the road, literally, on the ocean and then on the road. He's taken this interest in multinational corporations and human rights in multinational corporations to Freiburg, Germany, to Geneva, Switzerland. He's exposed our students to it here in Tulsa, and today he wants to share some thoughts with you over the next hour. So welcome, Professor Arnold.
All right, I'm Tom Arnold. Hopefully you can all hear me. A couple preliminary comments. Just for full disclosure, I am a business lawyer. I teach in the business law area. I'm not an international law professor. I'm not a human rights professor. I probably wouldn't be considered as a human right to be a human rights activist. Having said that, I still am, an individual, and I think all of us have to have some interest in human rights. And my work in this area in the past couple of years have suggested to me that anybody who works for any corporation that's a multinational or transnational has to have some knowledge in this area. My second comment is that in terms of the CLE materials, there's a small number of documents at the beginning. I kept the number low and the documents short on the hope that some of them might actually be read. I know there is this tendency for CLE materials for them to be discarded very quickly after the presentation. The rest of the written materials are basically copies of most of the PowerPoint slides. There are quite a number of them, and I'm not necessarily going to dwell on a number of them. My thought is, since I'm using the slides as the CLE materials, there may be some of you who later would like to examine some of this stuff, investigate some of this stuff, explore it a little further. And some of the slides have some references and URLs and so forth that will permit you to do that. Now, that sound was supposed to have been killed. I apologize for that. It's going to be very annoying. First question is, why think about multinational corporations and human rights? And by the way, most people today probably call them transnational corporations. That's kind of the accepted word or phrase now, transnational corporations. I've been calling them multinational corporations since the 70s. I haven't quite kicked the habit. Eventually I'll have to do that. Well, beyond the fact that as human beings we're all interested in human rights, one reason might be the size and power of multinational corporations. Another might be, if you're representing multinational corporations, just the spotlight that a number of non-governmental organizations have shined on multinational corporations. And I give you a link here to CorpWatch, and you can go there. And there's just a list and links to a whole bunch of these. But there must be 70, 80 fairly significant, at least non-governmental organizations dealing with this. In terms of size, and I had to take figures here from two different places. One was from the Fortune 1000, 2009, and the other was essentially, as I recall, World Bank figures from 2007. Those 2007 figures might have changed a little bit, but maybe with the global economic meltdown, they're not even that good today. But what you can see is if you take the revenue of the largest three multinational corporations and compare them to the gross domestic product of a number of nations that these corporations or similar corporations might operate in, you can get kind of a feeling for the size issue, that these are quite massive organizations. And by the way, you have to add something like, 6 zeros to the end of each of those numbers. I have a hard time when we get into billions. That's a revenue for ExxonMobil of $442 billion, or profits of $45 billion. So we're talking about a lot of money. I included just some popular quotes, figures that are kicked around. 51 of the top 100 economies in 1999, it's often stated, were corporations, and the sales of the top 5 corporations exceeded the gross domestic product of 182 countries. Well, that's pretty big. Another reason we might care is socially responsible investing. Now, these figures I've taken from a website, Social Investment Forum, but they report 2.71 trillion. Again, those are hard numbers for me to get my mind around. 2.71 trillion in assets under management using socially responsible investing. And also, their figures indicate a really significant growth rate here, a growth rate from 2005 to 2007 of 18%. Large number of socially screened mutual fund products, and also pension products. One of the options that we have as professors with TIA-CREF is a social responsibility fund. Consumer boycotts and outrage. Some of you remember Kathy Lee Gifford in about 1994 or so, and it was found that a number of her products were being produced in sweatshops in Central America, and then they found out that some of them were also being produced in sweatshops in New York, and it was quite a story. She testified in front of Congress and had a number of tearful appearances, and as I recall, her husband went around with a packet of cash to one of these places handing out cash. So it was at least an interesting story to follow. I've given you a citation to a to a site that has links to a number of current boycotts and successful boycotts, and there are quite a number of them. Some have been successful. Probably one of the areas where they've been most successful is with respect to companies dealing in Burma, or now, again, they changed the name on me, Myanmar, I think it's called. You have all types of political cartoons going after multinational corporations and their human rights records. And this is very powerful criticism, because this is something that catches people's attention and stays with them. Obviously, Nike is a favorite. Totalitarian Oil. This is a European company, Total Oil. Again, Chevron, quite a favorite topic. Another reason, of course, some of the major multinationals are concerned about it is that you have a whole bunch of sites that are kind of devoted to following the corporation closely, criticizing most everything they do. And here are some links I gave you to groups involving Walmart, Walmart Watch, Wake Up Walmart, and so forth. And of course, multinationals don't necessarily just stand around and be inactive here. They respond. If you were to go to the Walmart website, and a number of you have probably already done that, you would notice that they have all kinds of information on ethical sourcing, charitable contributions, disaster relief, and we'll talk a little bit more about ethical sourcing in the future. Now, one question might be, why don't developing countries themselves just get a handle on this? Why don't they pass laws that require these multinational corporations doing business in the country to behave, to meet what we would consider to be acceptable standards? Well, one is lack of expertise or resources. The most recent example here is a Swiss company that some of you have probably read about who dumped all kinds of toxic waste in Ivory Coast. You know, they wanted 400,000 or so to process it in Netherlands, so they just turned the ship around, and while it was on the way from Netherlands to Ivory Coast, a corporation was formed in Ivory Coast that said, yeah, we'll do this for 30,000, and they just dumped it all, and people started getting sick and so forth. So the problem is Ivory Coast just didn't even have the expertise or resources to deal with this kind of waste. A race to the bottom and the power of multinational corporations. A thought, if we don't have the toy factory here or the clothing factory here, they'll go someplace else. Preference of the citizens or the government for jobs and economic development over concern for labor standards or the environment. And frankly, if you think about it, probably some of these developing countries are where we were maybe 150 years ago, where we were going through our industrial development, and probably we cared a lot more about jobs and economic development than we did for labor standards, environment, and so forth. And finally, a real big one is corruption. And you have all this money that often goes to governments of developing countries, and it's just siphoned off. So there's a quite amount of corruption in a number of these countries. Now, John Ruggie, who's the special representative of the UN Secretary General on Human Rights and Transnational Corporations, has stated the root cause of business and human rights predicament today lies in the governance gap created by globalization. In other words, you have these huge companies with a lot of influence, maybe dwarfing the countries that they do business in, and there is no governance structure that really deals with this effectively. Now, in terms of framing the debate, one way in which we could kind of frame the debate about this topic is by looking at the essential nature of a multinational corporation. And you find that at various points in the debate, people take different sides of this issue. One view is, well, a multinational corporation is basically a private institution. It's property of the shareholders. And it's not some public institution. It's not some social institution. The other view is it's a public institution. It's a social institution. And this is based in large part, I think, on the size and the amount of influence that a large multinational corporation can exercise. I mean, we all do understand at a very basic level that what? Money is power. Money is power. Now, one way of thinking about this, and maybe some of you can't relate to this, but I'll ask my students sometimes, who has a bigger effect on your life on a day-to-day basis, the state of Oklahoma or Walmart? And for a number of them, it's Walmart. that had started the thing with the $3, $4 generic prescriptions and lowest price all the time and what have you. And if you're maybe a low-income individual on a day-to-day basis, Walmart may affect you more than the state of Oklahoma. I always follow that with a question, which is more responsive to your wants and desires, Walmart or the government? We'll leave that one. It's kind of, okay. Here's a classic example of the property view. It's from a famous case, Dodge versus Ford Motors Company, where the Michigan court said, look, a corporation is organized and carried on primarily for the profit of shareholders, and where shareholders have discretion, it's as to the means of attaining that end. It's not to change the end itself. And that was a famous case where back when Ford was making all kinds of cars, they were making more cars than they could sell, and Henry Ford decided to lower the price because not so Ford could make more money, but so that he could spread the benefits of the industrial system to employees so they could get higher wages, buy cars, consumers, and so forth. Here's obviously the poster child for this view. Milton Friedman said what? There's only one social responsibility of a business: make money. Frankly, the social or public institution view has probably won out recently. If you talk to politicians, if you talk to even CEOs of major corporations, I think the social or public institution view has probably won out. This is from the American Law Institute's Principles of Corporate Governance. And what it says is, even if corporate profit and shareholder gain are not thereby enhanced, the corporation may take into account ethical considerations that are reasonably regarded as appropriate to responsible conduct and may devote a reasonable amount of their welfare to these humanitarian their assets, to humanitarian, educational, and philanthropic purposes. A number of states have passed what are called other constituency statutes. And what these other constituency statutes say is that in making their decision, a board of directors may consider the interests of others beyond the shareholders. And probably about 25 to 30 states now have these other constituency statutes. Connecticut is unique in that it uses the word shall rather than may. Board of directors of a publicly held corporation shall consider community and societal considerations, and they may consider any other factor that they reasonably consider to be appropriate. Now, I'm not aware of any lawsuits that have been brought by individuals other than shareholders claiming that, I'm a community group and they didn't take my interest into consideration in making a decision. But again, shall does suggest what? Obligation, not discretion. British Companies Act. I just threw that in, but if you look at D&E here, British Companies Act of 2006 says a director of a company must act in the way they consider to be most likely to promote success of the corporation, and in deciding this can consider impact on community operations, on companies' operations on community environment, desirability of maintaining a reputation for high standards of business, and so forth. So again, seeming to adopt something of a social institution or public institution view of the corporation. All right. Of course, another way of framing the debate is just to ask the question, what are the human rights obligations of a corporation? Do they even have any? Historically, the focus of international law and human rights has been state-based, not based on individuals. That all changed with Nuremberg. In Nuremberg, you had private parties who were tried, and the Nuremberg trials made clear that private parties could be liable for certain violations of human rights, war crimes, crimes against humanity, and so forth. And there were a couple well-known cases. The case of the individual convicted for producing Cyclone B, which they used to gas people, and the person actually knew that the Nazis were going to use it for that purpose. Some Krupp officials were convicted for using slave labor in Krupp facilities. And since then, if you look at the international criminal tribunals for former Yugoslavia and the International Criminal Tribunal for Rwanda, there have been a number of private parties who have been pursued and held liable for war crimes, crimes against humanity, genocide, and so forth. But that's fairly narrow. Those are fairly substantial violations of human rights. Now, in recent years, there's been more focus on multinational corporations as a result of globalization, and I'll come back and talk a little bit more about that. Perspectives. We're going to be concerned mostly with legal issues. Why? Because this is a CLE program. But you can approach the question from all kinds of perspectives. One is the ethical perspective. And I think a very influential person here has been Immanuel Kant. And his notion that a person is not to be viewed as a means, but as an end. And that everybody, by virtue of being a human being, demands respect. And I think this has been tremendously influential in the development of human rights. In terms of business perspectives, one thing you can ask is, well, are we talking about long-term versus short-term? And it doesn't take a lot to realize that things that might increase long-term profitability might actually hurt. Things that might increase short-term profitability might actually hurt long-term profitability. And a lot of argument has been to the effect that corporations should think more about long-term profitability than short-term profitability. But a number of quotes here. The first one I showed you is basically the notion corporations don't actually act rationally all the time. I think there's this assumption that everybody in a corporation is always a rational profit maximizer, and that's just not true. Sometimes they do irrational things. And on top of that, and I particularly like this quote, that though multinational entities are very aware that corporate social responsibility can generate competitive advantages, they appear to be ashamed to openly admit that corporate social responsibility will be most effective when it works in harmony with sound business strategy. And what do then? They fail to integrate it into their everyday business activities. And you think about it, maybe some multinational corporations have to be more upfront and open about the fact that it can be good business. And if they do that, it may become a bigger part of the day-to-day. Now, I just threw this in because a number of you are lawyers, a number of you are going to become lawyers, and the question is, well, what extent do I even get into some of this stuff with my clients? Well, this is from the Oklahoma Rules of Professional Conduct. It talks about the attorney's role as an advisor. And it says, in rendering advice, a lawyer may refer not only to law, but to other considerations, such as moral, economic, social, and political factors that may be relevant to the client's situation. So your professional ethics permit you to raise these. And as I tell my students, sometimes if you as a lawyer don't raise some of these things, no one will. Okay? The saying you may have heard, sometimes the lawyer has to be the Grinch at the party and raise things that might be a little uncomfortable. All right. Overview of legal, in quotations, considerations. We're going to be talking about hard law, maybe some soft law, and maybe some stuff that's not law at all. Okay, we could get into the jurisprudential question of what is law. You know, most of you have had jurisprudence. You remember that with discussion with Dredd, and for those of you who haven't taken it yet, you have a lot of fun ahead of you. We won't get into that jurisprudential discussion of what is law. Okay, and these are the topics that I'm going to discuss. International human rights norms. Are there generally accepted human rights norms applicable to multinational corporations? I think so. And at a minimum, like private individuals, they have an obligation not to commit war crimes, crimes against humanity, genocide, and so forth. Now, this international criminal court that was established by the Rome Statute, some of you may be familiar with this, it's been a bit controversial, but when they set it up, they expressly gave a jurisdiction to the court over private individuals for these things, war crimes, crimes against humanity, genocide, and so forth. They did not give it jurisdiction over corporate entities. And the reason wasn't that a lot of people were against it. The reason was more that we treat corporations somewhat different in common law jurisdictions than in civil law jurisdictions, and a number of civil law jurisdictions did not recognize criminal liability for corporate entities. And so to get the thing moving, it wasn't put in there. Some of you know, I mean, there are cases in American jurisprudence where corporations have been convicted of various levels of homicide, okay? And the mental element being met by the mental element of the officers that's imputed to the corporation. Now, some countries have passed their own statutes to exercise this so-called universal jurisdiction that for certain crimes they're so terrible it's offense to everybody and it can be tried really anywhere. And Australia, for example, as I understand it, has included corporations in the group of parties that can be tried and found guilty in Australian courts. All right. There have been a couple failed attempts to promulgate norms covering transnational corporations or multinational corporations. The first one was abandoned in 1992. It was almost complete. It was never formalized or adopted. I think Reagan and Margaret Thatcher's appearance on the scene wasn't helpful to this effort coming to success. More recently, there were promulgated norms on the responsibility of transnational corporations and other business enterprises with regard to human rights. That's a mouthful. It was promulgated by the Commission on Human Rights Subcommission on Promotion and Protection of Human Rights. This really is a maximalist document. For example, I just give you one provision. But the basic point is this document did not focus on what we could call negative obligations. It didn't focus on basically the do no harm principle entirely, but it got into a number of positive obligations so that transnational corporations were to, among other things, respect and contribute to the realization of various rights, including rights to development, adequate food and drinking water, highest attainable standard of physical and mental health, adequate housing, privacy, education, freedom of thought, conscience, and religion. It was never adopted by the UN or by even the UN Commission on Human Rights, which I believe is now the Council on Human Rights. Frankly, as a political matter, if I were involved in drafting something and trying to get it accepted widely, I would not start by drafting such a maximalist document. I would start with drafting one that would focus more on do no harm principle, because I think you'd have, just as a matter of politics, a greater chance of success. Voluntary codes. There are literally hundreds of voluntary codes. And I just give you examples of a few in the materials. There are private company codes. You can find quite a number of these on the internet, but large number of companies have their own private company codes. Nike, Levi Strauss, Chevron. I give you a site to the Nike one, and I think I actually give you the Nike one in the materials. There are industry association codes, chemical industry, electronic industry, and so forth, that have a number of adherents. There are non-governmental organizations. The Global Settlement Principles is one of the very well-known ones that I give you a copy of in the materials. And the drafter was a well-known human rights activist, at one time director of GM, Reverend Sullivan. Other examples are the business principles of human rights, for human rights of workers in China. And under this one, an annual statement is expected from an organization. One of the ones that I think is actually fairly significant is the Voluntary Principles on Securities and Human Rights. And the reason I think this is significant is because if you look at the cases that raise, or the situations that raise human rights issues, they tend to fall into certain categories. One is the so-called sweatshop. And this is not just clothes. It's toys. Disney's had an issue with this with respect to production of toys. Another area is torture, death, so forth of union activists. A third one is extractive industries. There have been quite a number of issues that have resulted from extractive industries. And what's the reason? Well, the reason is that there are people who are living on land that these companies would like to mine, or they'd like to drill, or whatever, and they're not hot to leave. So they have to be convinced to leave. And so you've had arrangements where governments, private security forces, private militia have essentially removed some of them. Who was it that great American Dick Cheney who said, good Lord didn't see fit to put all the natural resources in democracies. In democracies we have an effective way, and what is that? We buy them out. And but part of the problem as well is that, frankly, a number of people in Africa and other places have a different view of land than we do. They don't have the view of land as just an economic commodity. They have a deeper connection with the land, perhaps something analogous to what a lot of Native Americans had and still have. That, I think, creates problems. These principles are a product of a dialogue between the United States government and the United Kingdom. There are now 5 governments who are members of it, but there are also 18 major oil and gas and mining companies and 8 international non-government organizations that subscribe to these. And if you read them, they make a lot of sense. And I think one of the reasons why they've been adopted is they were the product of kind of a process where a number of interested parties were brought in. And some of the stuff is just so sensible. One is if you're using security forces in a particular area, use to the extent possible people from that area. And if you look at Sudan, what they had was a civil war going on between Muslims and Christians, and they wanted to displace people in the Christian area. And so what did they do? They brought down Muslim security forces, and it's just a recipe for disaster, an opportunity to continue the civil war. All right. There are also public international codes of conduct. 2 really well-known ones and influential ones in their own way are the UN Global Compact and the OECD guidelines for multinational corporations. Frankly, there's a lot more depth to the OECD guidelines than there is to the UN Global Compact. It's something that's been committed to by not only the 30 OECD members, but 10 additional governments. And they are required to promote the guidelines within their jurisdiction. The UN Global Compact is a minimalist document. I put a copy of the basic requirements in the materials, this one page, 10 general principles with not a lot of specifics. Quite a number of thousands of companies have said we subscribe to them. Now the numbers are a little misleading because in some cases it's a multinational corporation plus a number of its affiliates and subsidiaries, so one could argue there's a little bit of double counting going on here. And supposedly if you follow this, you're supposed to file an annual document. It's called a COP or COP. And communication on progress. If you go to the site and you look at them, they are really kind of minimalist documents, in my mind kind of worthless, but more PR documents than anything else. One of the concerns that's been expressed with this approach, this very minimalist approach, and all these voluntary codes, and a number of corporations have adopted multiple codes, is that if there isn't a true commitment of the corporation to human rights, the multinational corporation to human rights, what you basically have is greenwashing, where they use their announced commitment to the UN Global Compact is more of a public relations tool than anything else. Are codes of conduct law? There's that jurisprudential question again. How are they enforced? Well, they're voluntary. They're voluntary. And if you look at a number of them don't have any enforcement provisions. They may have minimal reporting requirements. I don't consider them to be law, and a number of them really there isn't a whole lot of substance there to have violations detected, violations reported, investigated, sanctions applied, and so forth. All right. Ethical sourcing. This, to me, is actually one of the more fascinating aspects of this area. And it may be the area in which multinational corporations can have the most significant positive impact. If it's done properly and effective, the contract can have an impact that's similar to similar to legislation. Walmart does this, and it's been very active here. It has its ethical sourcing program, and its suppliers have to agree to various become their suppliers. They supposedly have a program of monitoring which includes announced and unannounced inspections. The most recent data I saw is 8% were unannounced. Frankly, I think that should probably be about 80% or more being unannounced. In terms of sanctions, I think a lot of what they do initially, at least, is try to work with suppliers who are found to be in violation. IKEA, a number of you are aware of, has very detailed standards. I give you a URL for that. Now, one question is, does a multinational corporation have exposure if it takes actions to promote human rights via contracts with suppliers? Now you say, well, how would that be? It's a fascinating recent case, and one of our students is writing a law journal article. Look for it. I think it's going to be great. On this specific case, this Doe versus Walmart case. And what you had was a number of plaintiffs who brought cause of action against Walmart, arguing, among other things, that they were third-party beneficiaries of the contract between Walmart and their employer in foreign countries, and also arguing that Walmart had a tort duty to them that had been breached. In this case, the court decided that Walmart had no legal duty under the standards or common law negligent principles to monitor its suppliers or to protect plaintiffs from the suppliers' alleged substandard practices. So, at the end of the day, the suit was unsuccessful. That doesn't mean there won't be the future lawsuit in another circuit and state courts that makes the same type of argument. Now, if you think about it for a minute, were these employees of suppliers in China, Bangladesh, Indonesia, and so forth intended to be benefited by the contract between Walmart and its supplier? Well, heck yes. I mean, if you go to Walmart's site and if you take literally what they say in their site and other sources, that's what they say. Okay? Now, from a contract law perspective, one problem is that the promise that is really breached is not a promise made by Walmart. It's a promise made by their employer. So one could argue under a third-party beneficiary theory they're suing the wrong party. They should sue their actual employer. Well, of course, that type of a lawsuit wouldn't necessarily have a high prospect of success because they might have to bring it in Bangladesh, China, or what have you, and I don't know anything about their contract law. The promise that they tried to enforce was Walmart's statement that it would do inspections, that it had the right to do inspections, and they tried to turn that into a promise and were unsuccessful in convincing the court that a promise laid in that. Are there legal risks to a corporation that defends its human rights record? The major case here is Caskey v. Nike. A number of you are aware of this. Nike was sued by Caskey for false advertising, violation of deceptive trade practices acts, and so forth for various communications that it had defending its human rights record, which was frankly under attack. And in a decision in which there was obviously a vigorous dissent, the court held that Nike's speech in defense of its human rights record was commercial speech, and the speech was not exempt from our state's consumer protection law. And that case, to my understanding, remains good law in California. So in California, you could still bring a case on that theory, and maybe other cases will follow. Now, Nike's situation was interesting because the California statute at that time allowed private individuals to sue as private attorneys generals. They didn't actually have to argue that they were injured themselves. That statute was changed after Nike, so now you have to actually prove that you were injured by the conduct to have status. My colleague here, Tamara Piety, has written several very good articles on the Caskey v. Nike case. You can find them very easily. One is entitled, "Does Nike Have a Constitutional Right to Lie?" I've recommended these articles to my students, and I've told Tamara that she does a really great job of representing the wrong side of the issue. She makes the wrong argument very well. Why do multinational corporations get involved in human rights issues? Why do they care about it? Well, we've already talked about a number of these, but, I have a bit of a recursive style, so we can double back and maybe talk about it a little more. One reason may be the preferences of stakeholders, customers, investors, managers. Consumers might not like it if their business practices implicate human rights violations. Socially responsible investors. Number two. I think number two is always important when you're dealing with large corporations, that very often self-regulation is viewed as a very good alternative to governmental regulation, because once you have governmental regulation, it's usually much worse than you would like. Business reasons to assure long-term availability of raw materials, for example, fish, forests, makes business sense. So there's a combination of ethical considerations. For example, managers are individuals. They may consider their own personal ethics. One question you can ask is there concern because they want to make the world safe for capitalism? And I think sometimes that's what you see with corporations. Let's do this so we can make the world safe for capitalism. If we don't, we may have problems. All right. How effective, serious are the efforts of multinational corporations? Overall, I think the answer is, who knows? Overall, it's probably an empirical question, and there are so many multinationals operating so many different types of businesses in so many different places that, looking at this globally would be a big project. I'm sure that there are a number that are very serious about it. I'm sure there are a number that aren't, and their actions aren't very effective. In talking about it, you have to ask, well, gee, what kind of monitoring if you have a human rights policy, or if you have a ethical sourcing program? What kind of monitoring do you do? How many inspections are there? How many are unannounced? Who conducts them? Are they conducted by an independent party? What are the sanctions? Is there any real bite to these standards? What is the depth? And this is one a lot of people don't think about. The question of how deep in your supply chain should your standards apply, or should you try to apply them? If you just apply them to the immediate supplier, you have a problem. They then subcontract with second or third tier suppliers who don't comply. Transparency. And I think transparency is a big issue. To what extent do you shine the light of day on what you're really doing? One suggestion is independent third-party monitoring of a lot of this might be helpful. And I give you URLs to two organizations that are involved in this, Social Accountability International and Business Social Compliance Network. I can't tell you in a couple minutes exactly all the details of what they do, but if you're interested in that, visit these two sites. Another thing I think that can be important is transparency. And I give you citations again to two sites here. One of the Extractive Industries Transparency Initiative campaign and Global Reporting Initiative. The Extractive Industries campaign is basically a publish what you pay thing, and when you get involved in it, what happens is if you try to get the government involved of the country, you try to get the multinational involved, the multinational reports what it pays to the government reports what it pays, what it's paid by the multinational, the numbers can be matched up, and one of the big problems in a number of these countries is the corruption and the graft, and you have all this money. It's one of the big problems in Nigeria. You have all this money going to the Nigerian government, and it all goes out by way of corruption, and not much of it makes it down. Global Reporting Initiative has more breadth to it. You can go look at the site. I give you the site to BMW's 2008 report, and these tend to be far more substantial, far more substance to them than the report you would get, this COP you would get under the UN Global Compact. All right. There can be objections made here. One is that this is all undemocratic. The other is it's private legislation. The other is it's government by multinational corporation. Maybe it's all the same thing. But people have raised objections to multinationals attempting to regulate things that are typically within the regulatory powers of a sovereign country. How do shareholders get information? Talk a little bit about shareholders. Well, there are a number of sources. Some of these you do have to ask about the accuracy or reliability of the information. For example, information on the internet, and we always have to work with students. It's on the internet, it's true. Not necessarily, but these are a number of things. From a legal perspective, they may get information from exercise of shareholder inspection rights for a proper purpose. They'll show that their concern about this information relates to profitability of the company, risks to the company. Generally not from SEC filings. SEC generally does not require reporting of human rights information, record, so forth. There are exceptional cases. One exceptional case is where you have major litigation that may affect the corporation. You may have to report that. One of the things I gave you that's real fascinating is on page 8 of the materials, this excerpt from Chevron's 10K, where they report about some litigation that's going on in Ecuador. And, no, not page 8, I'm sorry, page 7, litigation. This is one of those examples of be careful what you wish for. There was a case brought in United States court. Chevron moved for dismissal based on forum nonconvenience. The court did it, shipped it back to Ecuador. Reason most multinationals do this because studies show that the cases tend not to be then filed in the host country. Well, they filed it, and now they got an expert's report recommending that Chevron be hit for $27 billion in damages. And so what they did is tried to get at least part of the case back to the United States. This is what's referred to as boomerang litigation, and they're unable to do this. Probably the last thing that I'll have time to discuss, but the other things I have fairly good, I think, CLE materials on this, the lawsuit material. Shareholder resolutions. This is, to me, one of the most fascinating things. If you own $2,000 of stock in a publicly held corporation in the United States and you've held it for a year, you can submit a proposal. And the company needs to include your proxy proposal in its proxy statement and has to have a place on its proxy card where people can vote for it. And you can have a 500-word proposal and supporting statement. Now, of course, it can be excluded if it's improper, or it can be excluded if it's been submitted before and hasn't gotten a reasonable number of votes. But the bottom line is you get all kinds of proposals dealing with human rights issues under this rule. I give you 3 from Chevron's most recent proxy statement in the materials. They're very interesting to read. I've told my students when I retire I'm going to take my entire investment portfolio, I'm going to divide it into $2,000 blocks, buy his shares in as many multinational corporations as possible, and I will become the most well-known corporate gadfly in American corporate history, more than the Gilberts, who were famous corporate gadflies of past times, and I will just go from annual meeting to annual meeting defending my various proposals. All right. How successful have these proposals been? What do you mean by success? You know, what does this mean, right? If you mean success, how many have been passed? Not many. A few. Most aren't. Have they been successful? Well, a number of them are actually withdrawn. And a number of them are actually withdrawn because the company either implements the proposal or enters into negotiation with the proponents of the proposal to work out satisfactory solutions. So to judge success, you can't just look at the votes on these. But on top of that, the way a number of shareholder activists views it is, if we can make the annual meeting a public forum on this corporation's human rights record, we've succeeded. Because the corporation feels, that it has to defend itself, and sometimes maybe takes a close look at what they're doing. The remainder of the materials deal with 2 things. They're I think, fairly well developed. One is Alien Torts Claims Act suits. Some of you may have heard about these. And the other is suits. There have now been 2 that I'm aware of brought under state law theories against multinational corporations. These tend to be a real uphill sled. Prospect for success is low. There's all kinds of defenses that are raised. The fascinating part about it is the concept of this old statute that was passed in 1790-something to basically deal with pirates and allowing suits against the pirates if you could get personal jurisdiction over them, or people who dealt with the pirates in American courts. And in recent years, it's been then turned around and used against, in some cases, foreign governments, but in other cases, multinational corporations, typically under an aiding and abetting security conspiracy, joint conduct type of theory. I know of 2 that have gone to trial. Plaintiffs have lost in both of them. The first one went to trial when I was teaching this case in Geneva a couple of years ago. I predicted that a defendant's verdict in that case, for the reason that the facts in the case were much weaker than facts I've seen in a whole bunch of other cases. A number of them have been dismissed on various theories, including forum nonconvenience. But what you do have in a number of them, this is probably the most significant point for what we're talking about today, what you do have in a number of them is settlements, where this WeWa case, for example, was settled this past year. A Unicol settled a case in 2004. Total Petroleum settled it. These settlements have been criticized by some because they typically follow a format where the company uses the settlement almost as a PR opportunity. They settle but deny liability, and then a significant portion of the settlement funds go to general human rights, corporate social responsibility projects that aren't really tied in real closely to the alleged violation, and in some cases even to programs that the corporation already had in place. And so the argument here is that they're, again, just really using this as an opportunity to promote their human rights record rather than, in plaintiff's view, to take responsibility for their actions. I've run out of time. I will take questions from anyone who wants to ask questions. I will not be offended by anybody who has a 1 o'clock meeting, class, whatever, or just has had their fill if they decide to leave. Janet. Well, there's literature out there that talks about that, and it's one can see how one would take the position, and this has happened in a number of countries where they've privatized various governmental services, provision of water, for example, and then the issue is, what are the human rights obligations when you take over a traditional, state function? Should they be higher? And I think a good case can be made, yes, they should, because, and this has been made even broader than that, in a context broader than that. What about if you have a country where the power of the multinational, or let's say the influence of the multinational is extremely strong as compared to the impact of the government, so that we could almost say they control the geographic area. Should they bear human rights obligations that are more analogous to those owed by a state? What I'd have to say on that is I don't have a definitive answer. I know what the arguments are, and I think a reasonable case can be made, and it's been made in the literature, that there should be more demanding human rights obligations in that context. For the students, if you read the notes on the Alien Torts Claims Act stuff in particular, you'll get a trip down memory lane on some civil procedure issues. I know that's something you'd all like. All right. Well, thank you very much. I'll stick around if anybody has any additional questions.